Should terrorism suspects be tried in U.S. federal courts or in military commissions? That question is debated here by former chief prosecutor for military commissions at Guantanamo Bay, Morris Davis, ACLU Executive Director Anthony Romero, and attorney Joshua Dratel, who's defended terrorism suspects in military courts. Hosted by New York University Center for Law and Security, this is just under 90 minutes.
All right, so we're going to begin. My name is Karen Greenberg. I'm the Executive Director of the Center on Law and Security here at NYU Law School. Almost all of you we've seen before, so welcome back. Most of you know this is probably maybe our 30th discussion of trying terrorists in civilian courts or in military courts. Unfortunately, I think it may be our last such discussion, and so that's the note on which I begin. We'll give you a very brief overview of the context of today's discussion and then turn it over to our panelists. As always, tonight will end at 7:30. We will leave as much time as I can, given our loquacious speakers, for discussion, but I will begin the discussion with my own questions. As you know, the reason we've had so many of these panels is that the discussion of how to try terrorists that we apprehended off of American soil began with the invasion of Afghanistan, the U.S. invasion of Afghanistan in the fall of 2001. President Bush issued a military order, later renamed an executive order, in which he stated that those matters of detention and trial would be turned over to the Department of Defense for the foreseeable future, or for the war on terror. There are many details of it that I won't go into, but one thing that Eric Holder did when he announced that Khalid Sheikh Mohammed and others would be coming to trial in Manhattan was to make it very clear that the Obama administration wanted to redress what had happened during the Bush administration, which was basically taking many of the powers that could have been placed in the Department of Justice and giving them to the Department of Defense. And it was not insignificant that he picked the same day to announce Khalid Sheikh Mohammed's move to New York, or his intended move to New York. It was the same day that Bush had issued his military order in 2001. However, as a surprise perhaps to me and maybe others of you, that wasn't the end of the story. And what has ensued since November of last year and today is a very long, attenuated discussion about whether or not the United States can or should try Khalid Sheikh Mohammed and other of what are termed the high-value detainees currently held at Guantanamo Bay, should try them in federal courts, in civilian courts. There are many politics that surround this, and we will get to some of that today. There are many legal issues that are complicated, many that are still unknown, and we will talk about that today. But I think that this decision is going to be made rather clearly and rather definitively in the very near future. So I thought today the purpose of this is not, to come out with a let's do it one way or another. As you know, the Center on Law and Security has spent years working on the terrorist trial report card. We have examined nearly 1,000 trials that have taken place in this country that have tried not people apprehended abroad necessarily, but people apprehended here. But they have tested the courts in terms of terrorism, and not only that, they have created a profession. And so I thought we would really like to hear this vetted, not just from the point of view of advocacy of the federal courts, but what actually the military commissions could offer of us. There have been a number of military commissions acts, and our speakers can go through them. There is one that is currently, it would be in effect if we brought Khalid Sheikh Mohammed and others to trial under military commissions. It is a new act, and as a result, I'm not sure of all the details of it, but I will certainly push our panelists to tell us something about it. So what I'm really trying to say is that I'm hoping, and I say this to my speakers, this will be an open discussion, and with the open mind that what are the possibilities for trying these people? What is it we're trying to accomplish other than conviction? How much of this is about things that are really separate from these criminals or enemy combatants or whatever it is we want to call them these days? and how should we be thinking about this that maybe we're not thinking about that. So without further ado, I'm going to introduce our panel very briefly. You have their bios, and then I will ask them to talk. To my far right is Anthony Romero. Anthony Romero is a good friend of the center and one of my personal heroes. Because he has one of the hardest jobs in America, I think. I don't know how they do everything they do. He is the head of the ACLU, and he is responsible for all of the things that you read about in the papers that you both agree with and disagree with, depending on what day and topic it is. But Anthony is somebody who understands the politics of these issues and does not just advocate for his causes without thinking very carefully about who's going to hear it and what kind of compromises can be made and may be made for some kind of pragmatic end. And that's why I've asked him to join us tonight. Closer to me is, in every way, is Joshua Draytel, who, as you know, is my co-editor on two compendiums that we've done here at the center. He is one of our newest fellows. He is the person who's getting the most flack for our new blog, and I think you're going to enjoy hearing from him. On my left is somebody new to the center, Morris Davis, who I'm sure you know more colloquially as Mo Davis, who was the prosecuting prosecutor, the chief prosecutor at Guantanamo, really for pivotal years in which this discussion was going forward about who we were trying at Guantanamo, how we were trying them. He was involved in charging all three of the individuals who were later convicted at Guantanamo, and he was there for the conviction of David Hicks, who, by the way, was Joshua's client. So, and he has a rather interesting perspective because, and I will let him tell you this in his own words, he is no longer prosecutor, and I will let him tell you how that came about. And I actually think that he and I have talked prior to this. He's written on the topic of military commissions, of military courts martials, of the civilian courts, and I think that he adds a perspective that is not necessarily antagonistic, because that's not how this conversation I think is going to happen tonight, although it may, but is actually just he has a different take on how we might go forward, and so I thought it would be interesting to hear from him as well, and then we will hear from you. So we're going to start tonight with Joshua, who will tell us a little about the lay of the land as it stands now, and why we may or may not want to proceed towards military commissions.
Thank you, Karen. Thank you, everyone, for being here. Thanks also to the Center for sponsoring this program. I come to this issue with a dual perspective. One is as a criminal defense lawyer who has tried and been involved in a significant number of terrorism-related cases in the Article III courts, the federal courts as we call them, and also as someone who was involved in the first military commissions in 2004, representing David Hicks, and then the second in 2005, and the third in 2005, and the fourth in 2006 and 2007, and have been following in an unofficial capacity the commissions that have evolved since then. And I think there are a couple of questions that people might have about military commissions versus federal courts, and these are the natural questions. One is, what's the difference between the two? And the second is, why the difference between the two, meaning why would you choose to try someone in an Article III court versus a military commission or vice versa, and what motivates the preferences. I think first you have to look at the evolution and the history of the military commissions that we're looking at now, which began, as Karen mentioned, with a military order by President Bush in the latter part of November 13th, 2001. But the military commissions themselves were not effectively instituted until mid-2003 at all, with a few military orders, but then 2004 was the first iteration of these military commissions that charged 4 detainees, Hicks, Hamdan, and 2 others who nobody really, their names might not mean anything, so I won't bother. But Hicks and Hamdan obviously have attracted a lot of attention, being the first 2 cases that actually went to conclusion as well in the commissions. Those commissions were halted by federal courts, habeas petitions by Hamdan and Hicks that effectively that succeeded in getting a stay from a federal judge. So in the fall of 2005, after the initial decision invalidating the commissions by a district court was overruled by the D.C. Circuit, there was some administrative changes, and then also in the fall of 2005, there was something called the Detainee Treatment Act, the DTA, which again had an impact on the commission. So already you're dealing now with 3 versions of the commissions before you even have a single adjudication of any of them. And then in the summer of 2006, again before a single case had reached fruition in the commissions, you had the Supreme Court decision in Hamdan, which had finally went its way up to the Supreme Court, and the Supreme Court invalidated the commissions on a variety of grounds, including the statutory authority that, unlike the commissions that President Roosevelt convened in the famous Kieran case in World War II, and other military commissions that were held after World War II with respect to both German and Japanese war crimes, President Bush had acted unilaterally. In addition, there were other more procedural and substantive deficiencies in the commission system that the court found in Hamdan. So it went back to the drawing board generally, although there weren't a lot of changes made. But in 2006, in the fall of 2006, the Congress passed what's called the Military Commission Act of 2006, which instituted version 4 of the military commissions. There were 3 adjudications in the context of that commission. David Hicks pleaded guilty to what's called material support for terrorism and went home to Australia 2 months later. Hamdan was tried and convicted essentially of material support and was sentenced effectively to time served, which is about 5.5 years that he had served at Guantanamo, and sent home to Yemen. And a third defendant, defendant by the name of Al-Balul, one of the original 4, went to trial, represented himself, effectively presented no defense, acknowledged his membership in Al-Qaeda and his allegiance to Al-Qaeda, and was convicted and sentenced to life in prison. So those are the 3 cases. And then after the election of President Obama, he issued an executive order, I think his first executive order, as president, effectively staying all of the military commissions pending a review. And then in the fall of 2009, we had the Military Commission Act of 2009 with some further changes to the military commission system. Now, in terms of what's the difference? The difference, there are several differences between an Article 3 or federal court prosecution and a military commission. One is sort of the threshold is who can be prosecuted, and these military commissions are applicable only to aliens. No U.S. citizen is subject to these military commissions, which creates a discriminatory effect just as a threshold matter, and unconstitutional as far as those of us who have challenged the military commissions believe, based on a variety of different provisions, both constitutional and international. The rules in the commissions are different than the rules in the federal courts. In fact, there are no rules in the military commissions yet because the 2009 Military Commission Act has not been followed yet by a manual for rules. There was a manual for rules in after the 2006 Military Commissions Act, but that was never finalized either by the time we actually did Hicks. And in fact, in my last appearance in the military commissions in the Hicks case was not being permitted to appear on Hicks's behalf in April of 2007 because here we were about 6 to 8 months after the enactment of the Military Commissions Act of 2006. I was asked to sign a notice of appearance that said that I would abide by all the rules, including those that had yet to be written. And I declined to do so, and the judge would not permit me to appear. So rules are an important issue because the rules in federal court are rules that are promulgated by Congress that everybody knows, that are statutory or in the federal rules of procedure or case law that has been established by a 230-year history that has evolved. The military commissions doesn't have any of that. Resources is a very important issue in terms of what's the difference. In federal court, you are entitled to a lawyer, if you are indigent, you are entitled to a court-appointed lawyer in a capital case, which would be the 9/11 cases, as we've been informed by the Attorney General. Capital case seeking the death penalty, the defendant would be entitled to 2 lawyers, one of whom is learned in the law of capital cases, which is a very important reform of death penalty law as it was applied in the federal system, which has only had a death penalty in modern times since basically the mid to late 1980s. And the resources allocated in a federal case are extraordinary in terms of death penalty cases. Investigators, forensics experts, all mitigation experts who investigate family background, other issues, psychological background, all sorts, cultural issues. All that is required in the federal system. It is part of the framework of the capital resource center that exists for defense attorneys in capital cases, in federal cases, and also exists just as a matter of practice in the 20-year period that we've had the death penalty in federal courts. In the military commissions, in the previous system, before the 2009 Act, we had none of that. We had a military judge in the 9/11 cases who denied all requests for experts on the part of the defense in the 9/11 case, denied access to the defense to a variety of different experts and forensic issues, including the impact of the detention of their clients for 4 to 5 years, incommunicado, hundreds of incidents of waterboarding for at least one of the defendants, and no mitigation experts, no ability to do any of the kind of research and investigation that is de rigueur in capital cases in the federal system. Another important distinction is evidentiary. Whereas in the federal courts, the Fourth and Fifth Amendments would apply to both statements and to seizures, and would obviously have there are other aspects of it, well, speedy trial, the question of outrageous government conduct, which exists as a principle in the federal system. I think there haven't been more than 1 or 2 cases in the almost 40 years, I think it's 40 years now, since the case Russell v. United States that at least recognize the principle, but it's a very difficult threshold to meet, but at the same time it does exist, and one could consider the application of that in federal cases. In the military commissions, again, not necessarily applicable, we don't know, but this is all a clean slate, but it's not really a clean slate, it's an unclean slate in the military commissions, given the history that we've had with them for the past 6 years. In terms of why the difference, and again, it's also evidentiary in terms of the standards for admissibility of evidence, whether it's hearsay or whether it's how it's obtained, whether by coercion, by whether constitutional rights apply or any other rights apply, is an issue that potentially distinguishes, in some ways statutorily distinguishes the military commissions from federal courts, and in some ways remains to be seen how it distinguishes in practical terms. In the context of why the difference, there is, I think, a mythology as to the advantages of military commissions. For one, that we hear a lot of, and it's based, I don't know whether it's based on a lack of education about how the federal system operates or just a denial of how the federal system operates, is the question of secrecy and intelligence information. The federal courts have a statute, the Classified Information Procedures Act, we call it CIPA, C-I-P-A, that controls the use of classified information in federal criminal cases. And the courts have a perfect record in preserving classified information through use of the statute. There is no danger that a terrorist is going to come into possession of that information because they don't have security clearances. No defendant in these cases has a security clearance. Only their lawyers have security clearances, and their lawyers are permitted to review these materials based on their promise, essentially their agreement, to keep them confidential and only among lawyers. And that is what has occurred in dozens and dozens of cases, both terrorism and non-terrorism cases. Any national security case, there are many espionage cases in which CIPA has been used as well. And originally, CIPA was designed for espionage purposes, not for terrorism purposes. But that is something that is used in the federal system on a regular basis now. But the other issue about it is the government always controls in federal cases the ultimate dissemination of classified information. So that if I get classified discovery from the government and I see something that I think is advantageous to my case, and I say I want to use this in the court to establish my defense or to rebut an allegation by the government has the right to say to the judge, no, the government has 3 choices. One is declassify. which is always a possibility because they may find that the information is not sufficiently sensitive to warrant keeping it secret. The second is the government can offer a substitution that would be declassified and used in lieu of the classified information. And the judge gets to decide whether the substitution is sufficient or not. I can object and I can say, well, it doesn't really do everything I want it to do, but the judge can say, no, I think it does. And if the judge doesn't, the government can appeal to the Court of Appeals. And this happened in the Moussaoui case. All of these things have happened in cases already. In the Moussaoui case, and I'll just give you an example, statements by detainees in U.S. custody who the U.S. didn't even acknowledge were in custody, people like, I think it was Khalid Sheikh Mohammed and Ramzi bin al-Shib, but I'm not sure because I just don't remember precisely, but there were other cases. There's a case called Paracha in New York where two of the detainees' statements were put in evidence, substituted by the government, that the judge found were sufficient to give the defendant due process. The government can refuse altogether to give up that information. The government didn't have to use those substitutions. The government could have said, no, not at all, if the government thought it was too sensitive. Now, the court can sanction the government, can say, okay, and in Moussaoui, initially what the judge said was, you can't use the death penalty and you can't use the 9/11 conspiracy to convict Moussaoui. The government appealed and won. And the judge had to adopt substitutions that the government had proposed, and the government was allowed to seek the death penalty and use 9/11 in the case. That's just one of the mythologies. Another is that the military commissions will be faster. Here we are 6 years later with 3 convictions, and if Hicks didn't plead guilty, and we might still be we might still have a case going in that context, just from my personal experience. And these cases will drag on for so much longer than the closure that could be provided by a federal criminal trial, which does not have the issues of fundamental legitimacy that are challenged in the commissions and will continue to be challenged. And the difference, I think, is becoming more transparent as you hear more commentators speak. Those who want military commissions is really a dilution of defendants' rights, a dilution of the opportunity to defend yourself, to sort of prejudge these cases. And what you have is this sort of this topsy-turvy version of justice, which is the worst crimes with the highest stakes, not only for the defendant, but really for society as a whole, judged by a lower standard of proof and a lower standard of procedure. So that's the military commissions versus the federal courts.
Joshua, I have just one question. I mean, from the point of view of a defense attorney, I mean, all of those points are valid. But I'm interested in just briefly, just your thoughts about the purpose of having a public trial. And if that, not that the military commissions, or would it be public or wouldn't it, but what you actually think, or have you thought about the fact that we've had so many trials in the 90s that were international Islamic extremism cases where people who have done harm to Americans. And I'm just wondering, is there some benefit beyond protection of the rights of the defendants in the civilian courts that is beyond that for the society as a whole?
I think there are two important benefits among many of a public trial. And one, after 9/11, I think a significant part of marshaling international support for the U.S. response and the identification of al-Qaeda as responsible for 9/11 was in large part due to a public trial, the embassy bombings trial, which I participated in as a defense attorney. The vast majority of the 9/11 reports section on al-Qaeda and the history and evolution of al-Qaeda is culled. All the footnotes are from the testimony at the trial in the first half of 2001, which basically illuminated for those who were paying attention the nature of al-Qaeda, the existence of al-Qaeda. I have to tell you, I had journalists come to me before that trial started, international journalists who came to me before that trial started and said, don't you think that al-Qaeda is really a creation of the United States government designed to deflect attention and create another enemy now that the Soviets are no longer available? And by the end of that trial, I don't think anyone really could hold that point of view hearing the evidence in that trial. And the second part about public trials is I've heard people state that one of the advantages of a military commission is that we don't want to give terrorists a public forum or a soapbox in our federal courts, as if the military commissions haven't offered that more than federal courts ever would, in terms of a circus-like atmosphere where the defendants essentially have had a certain amount of control which they would not enjoy in federal court. But I offer the converse, which is that in the context of world opinion, in the context of where we stand now after 8 years of a failed policy in this regard, is I think we need the platform of a public trial as much or more than terrorists do, to make our case to the world that we abide by the rule of law, that our judgments are accurate and reliable and just.
Well, I think that's a good enough introduction to Colonel Davis. I think if you could bring us up to...
Karen, is your mic on?
It is. Sorry. Can you hear me? Sorry. I'll just talk loud. How's that? Is that better? If you can just talk a little bit about your experience and then talk about what you're thinking now and precedent and things like that.
All right. First of all, I want to thank Karen for inviting me. It's nice to be out of Washington. If you've been watching what's been going on there the last few days, I found there's a lot more civility on the streets of New York than there are on the streets of Washington. For me, the fundamental question, well, I think two kind of bedrock questions are, what are the source of the rights the detainees are entitled to? And I think one area where I probably have disagreement with my co-panelists, I don't believe they have constitutional rights. I mean, my view is if your only connection to the Constitution is a desire to destroy it, then you don't get the benefits of the Constitution. I do think they have rights under Common Article 3 of the Geneva Convention. So I think the first question is, what is the basis of the rights that the detainees enjoy? And then a second point that I tried to implement in the time I was there as chief prosecutor, there's a lot of talk about the common article and the common law, and there's an absence, in my view, of common sense. And to me, that was always kind of the touchstone, was what if the shoe was on the other foot? What rules would we accept if it was an American? No matter, how bad they were or how stupid their activity, would we condone it if the shoe was on the other foot? In fact, I was telling Karen, I turned on NPR last week, and I kind of came in the middle of the story. And the first part of what I've heard was that someone was being detained in Cuba without charge and been held for 3 months. And I immediately thought they were talking about the detainees. But it's an American citizen that they were talking about. That we were protesting, that they were holding an American citizen in a Cuban jail without charges. And I was thinking, well, my God, we've been doing that for 8.5 years now. So, my fundamental kind of touchstone was, what if the shoe was on the other foot? I think you have to, and again, I won't try to repeat everything that Josh just said, but I'd kind of look at it as past, present, and future. In the past, the military order that he mentioned that was signed in November of 2001, if you look at the order signed in the Kieran case, if you put the two side by, if President Bush had submitted his order as a law review paper, he would have been accused of plagiarism, because it was essentially taking the old order. It worked for Roosevelt, it'll work again, it'll be fast, it'll be easy, it'll be secret. And I don't know how many times I heard from Jim Haynes and others that, my God, the Nazi saboteurs were captured, prosecuted, and executed in about 50 days. And here we are 5 years later and nobody's gone to trial, so what's the holdup? It ignored the fact that the Geneva Conventions didn't exist in the 1940s, and there was another 60 years of development of the law that was completely ignored. I think you have to remember, too, that Guantanamo Bay, people weren't taken there with a view towards prosecution. They were taken there to be exploited for intelligence purposes. So I think one fundamental distinction that I still, this view about prosecuting in federal court causes me some doubt is that the things, if you look at like the underwear bomber, was immediately taken into FBI custody, advised of his rights. There was chain of custody on the evidence. All those things were lacking in the cases at Guantanamo Bay. There were no rights advisements. There's little, if any, chain of custody. There were some very enhanced interrogation techniques that were employed. A lot of things that I think would cause some real fundamental problems in a trial in federal court. So that's why the Bush administration worked really hard to come up with this unlawful alien enemy combatant designation, some way that could distinguish these guys from prisoners of war. Because if they're POWs under Common Article 3, they're entitled to a court-martial. And if you look at the rules for courts-martial and the federal rules, they're almost identical. So the problems you'd have in federal court, you would have in a court-martial. So they had to be creative and come up with another classification that could get around having to extend those rights, and that's where we came up with this alien unlawful enemy combatants. In the present, I'm extraordinarily disappointed. I thought in January of 2009, I mean, they hadn't even taken the bunning down from the inaugural parade when the president signed the order that said we're going to close Guantanamo Bay by January 20th of 2010. Well, that deadline has come and gone, and Guantanamo's still, going full speed. He also, when he campaigned, said that military commissions were defective and deficient, and they weren't suitable, that trial in federal court was the right way to go. Yet he's waffled back and forth on whether we're going to have military commissions or trials in federal court. And to this day, I think Karen may be overly optimistic when she said this has been a topic, 30 times, and it's maybe the last time. I'm not convinced that 8.5 years later we won't still be sitting here trying to figure out how to do this right. But for the present, the Military Commissions Act of 2006, I went over and met with John McCain and Lindsey Graham, and their question to me was, what do you need to get the job done right? And they made some changes to what President Bush had done in the initial military order. I didn't go as far as I would like to have seen, but it was an improvement. I think if you look at the Military Commissions Act of 2009, I was asked to review it. The phrase that came up during the election, lipstick on a pig, is what I would describe as the changes made by the Military Commissions Act of 2009. There's very little substance change. Like I think it gave the administration some top cover to say, hey, look, these are new and improved military commissions, they're not the Bush military commissions. But the changes that were made were superficial. One of the changes was under the old rule, a person the proponent of hearsay, which in most cases was going to be the prosecution, the burden was on the opponent to prove by a preponderance of evidence the statement should not be admitted. Now, under the new rule, the person offering the hearsay statement, most often the government, has to prove by a preponderance of the evidence. So you've shifted the evidentiary standard by 1/100%. And they're touting that as the big improvement of the Military Commissions Act of 2009. If you look at the people running the military commissions, Susan Crawford is the head of the military commission. She was Dick Cheney's inspector general when he was at the Department of Defense. At her retirement from the Court of Appeals for the Armed Forces, the only person she mentioned by name was David Addington, and she's running the military commissions. If you look at the folks, if you get below the level of Eric Holder and Jay Johnson, the folks that are still actually running the process are the same people that were running it when I was there in 2005 to 2007. So in one of the trials, Al Sharby was one of the folks that we had charged. He has a degree in electrical engineering from Emory-Riddle University. And he came in, the judge explained his rights, and the judge said, do you understand your rights? He goes, yeah, same circus, different clown. Well, here we've got the same circus and the same clowns that we've had for the last several years, and there hadn't been any change that I can see. For the future, if I were king and I could do what I wanted, I think one of the points that was mentioned about why we should have public trials, we kind of went it alone in the global war on terrorism. It was our way or the highway, and the Bush administration struck out on their own. I think if we really want to be a part of the global community, terrorism, in my view, is not a domestic issue. I mean, it's an issue that affects everyone around the planet, not just us. Also, and another issue, I think, is piracy. It's been an awkward fit. What do we do, with these pirates that don't really fit neatly into domestic law? So I guess if I were king, I think there ought to be an international terrorism tribunal, something similar to the International Criminal Court, to handle these kinds of cases. Now the problem is, we've been at it for 8.5 years and we can't agree domestically on how to handle this. So I think achieving an international consensus would be a bigger problem. There are also proposals for a national security court. It was interesting recently, if you saw Liz Cheney lambasted some of the DOJ attorneys that used to represent detainees. They called them the Al-Qaeda 7. One of those was Neil Katyal, who's now the principal Deputy Solicitor General, who represented Hamdan at the Supreme Court. And now he's being labeled, tarred and feathered as being part of the Al-Qaeda 7, as if he is on their payroll and adopted their view. Neil is a proponent of national security courts. So if he's on the Al-Qaeda payroll, they ought to get a refund, because that's clearly not what most people, I think, on the other side of the fence would advocate for. And then I guess, if we can't get to that point, this question of military commissions or trial in federal court, Again, I go back to, I think the rights the detainees are entitled to are the rights under Common Article 3. And in my view, either a military commission or federal court surpass that standard. But I think the administration needs to pick one and not try to have it both ways. So that's been my real disappointment. In fact, I wrote an article in November where I said the administration ought to, it's double standard justice to say some are going to get the full benefit of federal courts and the others are going to get something less. The 3 Americans that are being held in Iran right now, if the Iranians said we're going to give 2 a full trial and one's going to get something less, I would expect us to object to that. So I don't know how we can condone it when we do it and condemn it when somebody else does something, the same thing that we would have done. Now, I wrote an article about that. I was working for Congress after I retired from the military. I published that article, and I got fired for doing it. So I'm now Anthony's client. For a while there, we were kind of, the ACLU and I were kind of on opposite sides of the fence, and now they're my attorneys, and I'm very grateful for them. So thank you for defending me.
So can I just want to, I'm going to use a different mic, so whatever. Let me just follow up with one issue. When Attorney General Holder announced that KSM and others were coming to the Southern District in Manhattan, he went out of his way to say that this trial, he had very, strong belief that there would be a conviction, and that he would not be acquitted.
Right.
And there's been a lot of, I don't know if it's, under the table or over the table conversation about, well, what if he were acquitted? And I'm just wondering from your point of view, when you say, well, I don't care which one we pick, to some extent, we should pick one and we should stick with it. Does that come into your figuring? Do you think that there is just as much a chance of conviction in a federal court and of a fair trial in a federal court as there is in a military commission?
I think you could have a fair trial in either forum. To me, one of the many frustrating things that I encountered, is, I think Josh mentioned, there were 3 people that were waterboarded, including Khalid Sheikh Mohammed. In my view, having spent 2 years immersed in the evidence, there's ample evidence to prove the guilt of the 3 people that were waterboarded without using anything they ever said while they were in our custody. So this whole push to try to introduce that evidence, in my view, was totally unnecessary. And we could have the trial without using that evidence and I believe secure a conviction. I also believe, if you accept that this is war, and it's probably in a popular view, but if they're acquitted, as long as they're still an enemy combatant, they can still be detained to keep them off the battlefield. So an acquittal doesn't mean that give him a bus ticket to go wherever he wants.
Okay, Anthony, you're going to have to wrap up. And I would like you to talk a little bit about how you see the politics in Washington and whether this is a substantive issue anymore or whether it's really become such a political football that it's out of our hands.
Well, I think it has become a political football. But I think the implications of this football game are very serious for substantive reasons for rule of law and the justice system in America. And I'll just start out by saying, first, I appreciate Karen's great work and research. It's always, those of us who are the advocates, we have to rely upon individuals who will look at the facts and scrub them. And the report that she put out on terrorism trials has really been a very helpful tool for us to be able to show, in fact, that the criminal courts are equipped and, in fact, best able to handle these types of terrorism cases. If I put the same report out, the ACLU, my folks would read it, nobody else would. But it's really quite different that NYU does so. And to Colonel Davis and to Joshua Draytell, the one thing I love about my job is that what you will never imagine happens to you. And so I thought that when I started my job the week before 9/11, and then the whole world changed, including my work in it. And then the last thing I would have imagined, the first time I saw these 2 fellas, was when I was an observer in the military commissions back in August of 2004. I had finally been allowed access to the military commissions down at Guantanamo. And I wandered the base for about an hour before the DOD personnel found me. They were all having a nervous breakdown because the head of the ACLU was wandering the secure base of Gitmo looking for a place to stay until they found me. And it was a great article that probably gave Cheney a heart attack when it ran on a reporter's notebook in the Washington Post. And I saw both of these guys in action, and one of the last things I would have ever imagined then, back from 2004 till now, is that we'd end up agreeing on as much as we are. So it's always a live and learn process. What has played out has been a complete capitulation of what are clear promises that the president made, as Colonel Davis laid out. And a possible reversal of the Attorney General that would be catastrophic for that Justice Department in ways I'll enumerate in a moment. And it's all politics. It's all politics all the time. It's that they have fumbled the ball in terms of how they were going to announce and deal with the New York venue. The Justice Department screwed it up, quite frankly. Phone calls were not made to the mayor or the relevant senators or members of the House, who were gracious enough to acquiesce that morning, but then as they began to see some of the dust up in New York, they didn't have much buy-in to a decision that was forced upon them. And it was, frankly, mishandling of the Justice Department, of how they were going to reach out to constituents in this city that could have been handled much better. And then from there, the thing begins to unravel. The not in my backyard resolutions, the kind of the pontificating of different Republican senators that then give some reason for the Democrats to begin to inch away from their commitments. Hence, you see the changes of decisions by Mayor Bloomberg. And they really didn't play hardball on some of these issues. Ray Kelly saying that these trials are going to cost $200 million a year. Who rebutted the fact that that number is absolutely outrageous? You know, as I understand it, and there might be others in this room who know much more, I know some notable members of the law enforcement community are here. I've been told that the full police department budget for all of our 40,000 police officers annually is up $1.2 billion. So how can this police commissioner get out there and assert these numbers without anyone saying, show me the numbers? How do you calculate that? What's it actually going to be? Where was the response to these local officials and local citizens about the shutting down of Lower Manhattan? And I don't know how many of them have walked through the federal court system down in Foley Square. It's a barricaded part of the city already. It is, God help you, if you have to get through there during a traffic time. And so a lot of hyperbole played out in a way that really let the ball get away from the Justice Department. Now, enough of the commentary. Let me tell you what I think the realpolitik is of such a decision to reverse this course. Leaving aside the civil liberties principles, which are near and dear to my heart, but you take the principles and you play politics. So obviously the biggest concern we have is that the military commissions are an inferior form of justice, just as Joshua laid out, and that we should never use an inferior system of justice to adjudicate some of the most notorious criminal defendants in modern history that will rival the trials of the Rosenbergs. And so if you use a second-class system to achieve an outcome, you forever have that outcome in doubt. But what's the realpolitik? If the West Wing reverses Holder and even forces him to do a Saul to Damascus speech, which is what is speculated, that the Attorney General himself will not allow the Ron Emanuels of the White House to reverse him. He's going to take it on the chin and say, I've changed my mind. It shows such a politicization of the Justice Department that reeks back to the Gonzales and Mukasey years. And part of what we've been trying to get out from under is the idea that people in DOJ are taking their orders from someone else on Pennsylvania Avenue. And the demoralization of people who talk to me in DOJ, it's amazing the leaks in this administration, because they're demoralized. People within government talk to the likes of me because they're fed up by the fact that they can't get the job done. And that's likely to get even worse and continue as they go forward. The other reason why it won't work, the realpolitik, and I think Josh and Mo Davis have said this, although Mo perhaps is a bit more optimistic. My mind is that the military commissions are never going to work. They're never going to work. I don't like predicting, but on this one I will predict. You know, the record of thousands versus 3 convictions, the lack of rules, the inadequate resources that are down there. For having sat in those military commissions probably about a dozen times, from the first round of the convictions to the one I was just down there in January right before the president signed his executive order, it's a complete and utter joke. You know, the rules, lawyers stand up, they're making motions, cross motions. A judge in the courtroom where I was there said that this was a learning experience on capital cases for the most notorious criminals, and we're calling it a learning experience. In God we trust in the background. It's absurd. The translations, I don't speak Arabic, I speak Spanish, English a little bit. You hear perfect full paragraphs of flowing Arabic with lots of passion. And the translations are fragmented words, no finish to the sentence. You kind of sit there and like, well, the guy just spoke for 4 minutes, and how can the translation from Arabic to English be less than a minute? That's how we were doing it. Those of us who were not Arabic speakers, we would just clock it. Okay, how long is Al-Balol speaking? 5 minutes. How long? This is what we did as monitors. How long was the translation? 30 seconds. Okay. It's just, and unless they have found a whole new cadre of translators down in Guantanamo, it's going to continue to break down. And that's just the infrastructure, the legal issues, which Josh already outlined. If they go down this road, it's going to be a lot of fun to tie up their knickers in a twist on the legal issues. On the hearsay evidence, litigated to death. On the coerced evidence, you bet. On the question of the undue command influence, the president is going to find himself exactly in the position. Josh is the one who educated me this. You can tell I'm a pretty good student. I've retained some of this. When the commander-in-chief says these people are guilty and should be put to death, he can say that in an ordinary Article 3 criminal court context because judges have lifetime tenure and they don't have to listen to what the president says. A lot of them do, like the Supreme Court. But ideally, and the way it's supposed to work, is that you have an objective third branch of government that can say the president might think they're guilty, but I, Your Honor, Judge blank, don't have to follow that. In the military context, you have this thing about the commander-in-chief is the boss of everyone down the line in the military. And so the question is, by Obama and Secretary of State and Secretary Holder having said these guys are guilty, you're going to be able to lay a lot more gloves on this president, which were the motions that Josh and his folks filed on the undue command influence. They're going to find themselves exactly in that same legal morass. It will take a lot of time. So guess what? You're going to be running for office in 2 years, right? You're going to be running for office in 2 years, Mr. Obama, if I were speaking to him, which I'll tell you about that in a second. And you're not going to have convictions on these cases. You will have shown that in fact, you didn't do any better. There'll be increased pressure from the 9/11 family members when they haven't rendered justice for their family members. It's a complete mistake to not use the criminal courts that are the quickest, easiest, and most sure way to get a conviction. Finally, I love the optics of this. I mean, the idea, you're right, Mo, if I can call you that. You're right that there's so much evidence, from what I hear, I haven't seen the evidence, that there's so much evidence on some of these high-value detainees that you don't have to use the evidence gleaned from torture to convict them. But when you're in a DOD context, when the adjudicator of guilt is the very same administration, same agency that perpetrated the torture, boy, are you giving us a place to litigate the torture issue. Whereas in criminal courts, a good judge would say, that's irrelevant. That evidence wasn't gleaned from torture. Who cares if your client was waterboarded? But when you're in the military commissions under DOD with some of the same people who possibly were involved in the torture, you'll have a lot more fun. I say this, in the realpolitik, if I were talking directly with the president, and which I've talked once, but not on this issue, it's been quite interesting. I only got the week leading up to the big press release. We were scrambling to get all the people who were so nice to me and invited me to the White House the first time around and gave me their phone numbers and their cell phones and their business cards, and we want to hear from you. And when we heard the rumors that they were going to switch to military commissions, we tried to activate the behind-the-scenes channel. Not a phone call. DOJ or White House. Where I got phone calls back, ironically, was from DOD and the FBI. Go figure. And so the only way we knew, from folks who talked to us, we knew that the decision was being made at 1600 Pennsylvania Avenue. And when you don't get the hearing of the White House, you kind of have to scream. And that's when we ran this full-page New York Times ad that said, "What will it be, Mr. President? Change or more of the same?" That was admittedly provocative and very cutting edge and created a lot of debate within the ACLU whether we were being too hard, with a picture of Obama on one side morphing into Bush on the other, where one picture then has Bush's eyebrows, and then it has Bush's nose, and then it has Bush's shape of his head, and you can see the progressive transition to it. And a lot of people say, "Oh, this is too rough." It was too rough. It was a question. It wasn't a statement. So what will it be? So we tried to be respectful in it. It was only Monday morning that we got the call back from the West Wing. Then we spent an hour and a half with them, talking them through the realpolitik and why this would be a Faustian bargain. And frankly, what we were able to say to them, look, what do you want to really accomplish in these trials? You want a speedy conviction. Get this over and done with. You want to put this albatross that you inherited off of your neck. You want to do it under established rules that have legitimacy, right? Where no one's going to be able to poke at how you got the job done. You want to seek an execution, but do you really want to execute? You want to make these jihadi poster boys? I understand why you might want to say you're seeking the death penalty, but is that really the best public policy decision in terms of relationships with the Muslim world? And if you back into it that way, you have many more opportunities about venue and using criminal courts that don't limit you in the way that they seem to now be limited. I say ultimately, the reason why the military commissions, Mo, would be an enormous mistake, just as a rejoinder, it's going to be the exception that eats up the rule, meaning the Fourth and Fifth Amendments. Because I also, not given to prognostication, I know that these types of situations will turn up in organized crime, gangs, the drug war, and we've seen it with the Patriot Act. I mean, this was something that I can point to explicit proof. You look at the annual report put out by Department of Justice on how the Patriot Act powers were used, right in the aftermath of 9/11, 1 month after the attacks of 9/11. It's used on lottery crimes, embezzlement, people who were extorting the elderly, environmental terrorism, immigration. And I guarantee you that if you allow a context where you can convict individuals with hearsay evidence, with coerced evidence, you can hold individuals preventatively without charges or trial, then you're going to find yourself in a situation where that exception becomes the rule of law and eats up what are very clear barriers for due process in the Fourth and Fifth Amendments that will do enormous damage for the country. That's why this issue is of such high importance for us. People keep saying to me, I'll wrap up with this, why do you spend so much time focusing on these 200 individuals? I just got this question at lunch. You have 2 million people in jail, and we litigate the conditions of confinement in U.S. prisons. But the reason why we have sunk $3.5 million into this project, the John Adams Project, which Josh was the architect of, to bring the best of the best in terms of criminal defense lawyers to supplement the good men and women in the uniform, the JAG lawyers, is to ensure that if you lose this game, you lose a lot more than just 200 cases or clients. The implications for us going forward are not to be underestimated. And that's why, frankly, the idea that we're dealing with potentially carving out enormous exceptions in our established justice system because of the realpolitik of Washington is just incredibly frightening, and why the questions and comments from across the political spectrum have to be as loud and as vociferous as possible, regardless of where we end up. So thanks very much.
So, Anthony, I want to follow with a question, which is this issue of it bleeding into the criminal justice system across the board for other kinds of crimes. Do you think we've already seen that? Because one of the things that's happening with the civilian military courts discussion or debate is that we've had the discussion of Miranda. We've had this, or not. We've had the discussion of preventive detention. We have the overall discussion of what it means to close Guantanamo. Does moving them actually close it? And so, are we going to try anybody in civilian courts is also out there as a question.
Right.
And so, really, what I want to ask you is: do you see that eroding already, or do you think it's still something in the future?
No, I think you're exactly right. It's eroding already. The question of either though codifying it into law, and doing so either with a Democratic president or a Democratic Congress, makes the exceptions and the holes that have already been poked through the Fourth and Fifth Amendment that much larger that you can drive a truck through them. And what is remarkable is the lack of public outcry. I will give you one anecdote on this one. I was dealing with budgets. Part of my job is to run an organization in this economy, which is not often easy. So in times where I have to go underground and go underwater, I don't pay as close attention to the emails or the blogs. And I got a phone call from someone in the government, in law enforcement, in my cell phone in the morning, saying, "Where the hell are you on this underwear bomber?" And I said, "Well, there's nothing for me to do. You arrested the guy, you read him his rights. That's the way it's supposed to work." And I was told, "No, we're getting clobbered on the Hill and in the press for having read him his rights. We need to hear from you," which is incredible. Usually I get phone calls that ask me to stay out of a controversy. They don't ask me to jump into it. But ironically, here we are in a context where law enforcement did it the way the FBI did it, exactly the way they were supposed to. A guy on American soil, which we might disagree, Mo, in an airplane in Detroit, tries to blow up his fellow passengers. You kind of have to read him his rights. That's not a discretionary rule. You got to charge him with a crime. He's in America. He is on American soil. Even if he's not an American, he's on American soil, and we've established that. We have lots of undocumented immigrants who break the law, and yet we don't not read them their rights or hold them without charges or trial. And that's why the exceptions that could be, that if you allow non-citizens to be apprehended for these narrow cases where they're not read their Miranda rights, we'll be seeing a lot more of that, I think, with your ordinary Mexican undocumented immigrant under a DWI case in future years. And I think the possibility of that morphing it's certainly borne out by the facts that we've seen in the aftermath of 9/11. Look at the immigration enforcement issue, the massive deportation of immigrants in the aftermath of 9/11 who had nothing to do with terrorism. And it's when you ever get that fear-mongering and those lax enforcement of the rules, you're going to see it play out.
Of course, we're going to get to your questions. I just want to make a comment. The Patriot Act has not gone away.
No.
And how the future in the Patriot Act deals with so many of these issues is in all part of the conversation that we're never going to get to.
Obama defended every one of the powers that were up for renewal in the Patriot Act. And the most we could do was to shorten the time period whereby we can take another bite at that apple. But they made the same arguments for the very same powers that were put in place under the Bush years. There's very little substantive difference in the policies and pronouncements of the Justice Department and national security issues when you look at some of these cases. The Jeppesen data plan case, our rendition case, same arguments, same clown, different clown, same circus, let's say.
But just...
I'm being provocative.
No, there are some differences, and one of the differences...
We don't torture. That's
a big difference.
Sure.
And there are some differences of intent, and also there's some differences of alliances, as you've pointed out. I mean, when we started the terrorist trial report card, the idea was to embarrass the Department of Justice. Halfway through it, we realized that really it was a different story than we'd started out finding, and everybody had already gotten into their corners, and the corners aren't the same, because now the issue of civilian and military trials has put people who debated how we try domestic cases into, sort of on the same idea that we want to use civilian courts. And so it's kind of a weird realignment, which, while I'm saying is, this could happen down the road with the renewal of the Patriot Act.
Sure,
so
sure.
Maybe.
Point well taken.
Okay.
This is why you need the academics to bridle the advocates.
No, it's called a moderator. So we're ready for your questions, if you have them. Jay. And turn on. You have to turn on your thing tonight. Yep.
Hi. I assume that the case that we're talking about that were transferred to the U.S. Attorney's Office in New York and they're talking about taking back have been vetted at the U.S. Attorney's Office, and they went through the evidence and they examined whether or not they can get a conviction on the issues that would not raise constitutional questions. So my hypothetical is there are other cases out there that haven't been, and so the hypothetical question is that somebody confesses to a terrorist act, but they confessed in a coercive confession, but that confession is corroborated. So we know that they're actually a terrorist, and that's the evidence that's submittable. Do you think that what we should do is we should transfer the cases that we haven't seen yet to the to the Article 3 courts, and these people should be acquitted, or maybe you just keep them in prison without any process at all?
Well, I think there are two parts of your question that I think are not consistent, in the sense that you say that you have a confession obtained by torture that is corroborated and therefore may not need that might be put it in the same position as the 9/11 cases, in which I think the government, and the Gailani case too, because if you look at the Gailani case, which is a great example because it's going on right now in New York. He was charged in the embassy bombings case in 1998. He was apprehended in 2005, I think, in Pakistan. Was held in a black site for three and a half years. Was transferred to Gitmo at the end of 2006, I believe, with the other high-value detainees. Was transferred to New York. He's in federal custody in New York since at least June of certainly no later than June of 2009, when his case was essentially resuscitated because the embassy bombings case had essentially been over for a long time for the other defendants who'd been tried and in custody already. But Gailani is a case in which the government has forsworn his statements and is relying on the other evidence that they had previously. For which he was indicted in 1998, long before he was ever in custody. So that's always a choice for the government to make in that regard. So in the sense, and it may be difficult to comprehend this, and I'm being serious about this, and I understand from the point of view of the public, if you're not involved in the criminal justice system on a daily basis and on a comprehensive basis, which is that despite what you read in the newspapers, some people who you absolutely certain are guilty aren't. How many people thought John DeLorean was guilty when they saw that video? I may be dating myself. We're going back now, 32 years almost? It's 1978, I guess. But really, how many people really doubted that John DeLorean was guilty? He wasn't. He was acquitted by a jury, unanimous, 12 jurors. Really no doubt in their mind that that particular video that showed him opening a case of cocaine was a complete setup for him. So you have to let juries decide the facts of these cases. And, if Khalid Sheikh Mohammed got acquitted, he had to be not guilty to get acquitted. I mean, come on, really? Anybody charged with 9/11 would have to be not guilty in front of a jury of New Yorkers or Americans anywhere to be acquitted. Now, everybody wants to focus on Khalid Sheikh Mohammed. What about the other four? Who can name all four of them? What do you know about them? Do you think it's going to be fair? They're going to be tried with this guy in a military commission just because they're tried with Khalid Sheikh Mohammed? So I think that each case has elements of it, and we want to get into false confessions even without coercion. But the question of the whole dynamic of false confessions, particularly in the context of coercion, is extreme. And look, the consequences are also extreme. There is someone named Sheikh al-Libi, who was a pivotal part of Colin Powell's presentation to the UN in November of 2002 with respect to the basis for attacking Iraq and the presence of weapons of mass destruction by Saddam Hussein. And Sheikh al-Libi was an al-Qaeda operative who'd been apprehended after 9/11, who said that there was a connection between al-Qaeda and Iraq, and it had to do with weapons of mass destruction and all of that. And a couple of years later, it turned out that, well, he had been tortured and recanted, and his confession was deemed, even by law enforcement people and intelligence people, to be invalid, to be false. So think about the consequences of that when you go forward.
I was asking a different question, by the way. I was asking a hypothetical. I'm saying, given a fact that the U.S. attorney looks at a case and says there will not be sufficient evidence that under the current laws that will acquit this person, and in fact they knew he was guilty. And this is a hypothetical. It may not be true. Your answer is, how do you know that's really valid? But the question is there any circumstance where the government should, in fact, acquit somebody where it's popularly thought and the government truly believes they're guilty, but the evidence is not sufficient that would pass muster in a court? That's
the rules we play by. I mean, if we're not going to play by those rules, it's anarchy, actually, is what it is.
Go ahead.
Yeah.
You're fine.
There we go. One of the things that really concerns me about this, having these two different systems, one of the criteria that they came up with to evaluate which forum the cases would go to is which forum would allow for the best presentation of evidence. There's words to that effect. So it's basically what they were saying is, let's take a look at the evidence and see what bar it will clear. And if it'll clear the high bar, then let's give them, a full-blown trial in federal court and feel good about, giving them a full measure of justice. But if the evidence won't clear that bar, then we'll fall back on a military commission. And that's exactly what they've done, or vet the cases and determine how high the evidence will jump. And that's what picks the forum, which I think is just fundamentally wrong. And I think the harder question, I think the prosecution, where we prosecute these cases, is a fairly easy question compared to the larger number of people we have no intention of ever prosecuting and never releasing. And what are their rights? That's, to me, is the more difficult question.
To that point, I would say we ought to give it a whirl before we start rewriting the Fourth and Fifth Amendments. So I hear this argument that there might be 30 or 40 people who are bad folks who will do damage to the country that we won't be able to convict in either the Uniform Code of Military Justice or military commissions or in Article 3 courts. And what do we do with them? Well, first, I think you got to give it a whirl. I happen to think that with the growth of anti-terrorism laws that have been put in place in the aftermath of 9/11, forget the part of the Patriot Act. There's been so much more in addition to that. It is so much easier to convict people for crimes after 2001 that you couldn't go after in before 2001. The material support for terrorism, it can be read so broadly as to barring lawyers' assistance to humanitarian groups. That's a Supreme Court case that's now before the court. But we ought to try it. And I think that if in established rules, which I prefer not the military commissions, I prefer the court martials, the UCMJ and Article 3 courts, those are my two lanes that I find acceptable. If you can't prove a person is guilty, then they walk. That's what happens in America. Guilty people walk when they're not convicted. And if they are radicalized now after being in Guantanamo, does not mean that they were radical extremists when they got there, because that experience will radicalize most anyone. And so you're going to hold them guilty for a crime that the government committed on them by breaking the rule of law and having a different ideology on the way in than they had on the way out. And I think that would just be a debacle for our society.
Colonel Davis, I want to ask you a question about this, just from your years at Guantanamo, because during the first, 6 years of Guantanamo and then spilling a little into now, there have been, by my count, over 600 detainees from Guantanamo Bay who have been returned home and are free. Some of them have likely been radicalized. Others are predicted to have been radicalized. Was there any discussion of this, to your knowledge, at Guantanamo Bay, where there was some idea that there were these 4 people who were being charged, and yet this sense that we were letting people go back that is now what everybody's afraid of in this particular debate that's going on?
There was some of that. In fact, one of the ironies, one of the jokes we used to make was in order to like David Hicks and Salim Hamdan are convicted war criminals, and they're free men. And you've got a couple of hundred other people that have never been charged, and they're still behind bars. So one of the jokes was you've got to lose in order to win. You got to go to court and get convicted and get a misdemeanor punishment for being the worst of the worst in order to get to go home.
Okay, more questions from you? Yes.
Yeah, I'm having trouble reconciling how Common Article 3 can provide. Well, when I think Common Article 3, I think of undue command influence. The executive cannot be in charge of the court that charges you with a crime. And I'm trying to reconcile how Common Article 3 can be applied to the military commissions. They don't seem to reconcile in my mind.
Yeah, I think, and again, I think in the Hamdan decision, Justice Stevens said you really have to look at the additional Article 75, the additional protocol that kind of lays out what the fundamental rights recognized by civilized people are. And if you look at those rights and compare those to the Military Commissions Act, I think, in my view, you clear that bar. So it's a question of, what, again, I think it goes back to what are the source of their rights? Do they have constitutional rights and Fourth and Fifth Amendment rights? I mean, if anything, the Bush administration may have conferred constitutional rights where otherwise they wouldn't have had we done this right from the start. But I think that, the military commissions could satisfy the the Geneva Convention requirement. And your same point would apply. When I was on active duty, if I faced a court-martial, the commander-in-chief was still the commander-in-chief, and I was still prosecuted in that same system before the same panel of officers. And I guess another comparison that in federal court it takes 12 people saying you're guilty, and a military commission or a court-martial will say 2/3 vote. So 4 is greater than 11 in a military commission. So it's not an apples and apples comparison.
Other questions? In the back.
I want to ask sort of a practical question. I think it seems pretty clear that colleague Sheikh Mohammed is going to end up in a military commission. So my question is, what's the half loaf that would make you happy?
Talking to us bagels.
Happy is the wrong word. Let me start out with sort of wiping away the last 8 years, because that has a lot to do with sort of the theoretical position. I do not oppose a properly constituted military commission to try war crimes. I think that what we have now is a situation that is too toxic in the context of what these military commissions are, and they also don't meet the standards that, at least for myself, in 30 years of litigating, have come to believe provide a reliable, fair, accurate adjudication of guilt or not guilt. And I don't think the military commissions are there. Could there be a military commission that says, yeah, the UCMJ provides that system? We have never argued that the UCMJ, as it is constituted presently, would not provide a fair trial. Ironically, there are elements of the military system that are more favorable to defendants. Discovery is far better in the military system than it is in the civilian system, in the criminal courts. The breakdown of jury voting can be good and bad. I mean, the question of not having to have a unanimous acquittal is something, because all you got to get is more than a third. And we did all the math, and it's funny, in the Hicks they just knocked it down to where all of a sudden, so instead of having 7 jurors, we had 3, because we ended up getting a couple disqualified. So, that really changes the percentages of what you have to do. It's really an extraordinary difference when you look at trying to convince 2 out of 3 as opposed to 3 out of 7. It's very different. Or 2 out of 7, I should say. Right, 2 out of 7, But I've never taken the position that a properly constituted military commission would not be a viable means to try a war criminal. That raises a second question also, which is, what is a war criminal? I think that much of what we're talking about, particularly when you're talking about Abu Muttalib, the Christmas Day underwear bomber, you're talking about a criminal offense, and plain and simple, not a war crime. And the question of whether you can backdate war crimes to define them now and charge them for conduct before they're ever delineated as war crimes. But you can't erase that 8 years, and that's the problem.
Anthony.
I guess for me, I think I love the questions you asked, Dina, because they're the hardest ones. I don't think that's a half of a loaf that I even would bother eating. Frankly, I think just for all the reasons you say, the implications, the precedent behind it, the fact that the jurors are going to be military officers, not a jury of American citizens, troubles me. And I think, frankly, this will come as no surprise, our whole goal is to blow these commissions up just like we blew them up under the Bush years. We'll play for time. We'll show just how bad they are. We will roil it. We did it. We gave it when we jumped in after Boumediene and we said, okay, now they have rights. What do we do to make sure that these rights are secure? There's not much you can do to secure their rights. You can blow up that military commission system. And that will be, I think, the next round of what we do. Now, if you wanted to diffuse me, which is often the question, I think that some of you want to kind of make it harder for me to do my job, I guess someone could get up there and say, we're going to run these military commissions in a very transparent and accessible way, and we're going to uphold every single legal standard, and we're going to, that you would have in Article 3 courts. And we're going to resource this case just like we would at Article 3 courts. But if they're going to push forward, Obama wants to push forward and use the military commissions, set a really high bar so that the likes of me can't be jumping over that bar too easily, although we'll try.
More questions? Over there.
Is there a right of appeal from a military commission, and does the appeal apply to rulings of evidence, etc., and to the decision of the court?
Yeah, the way it's set up, there are actually 4 layers of appeal. I mean, one of the things I used to really hate when I was on the prosecution side is people would say, they'd hold up Nuremberg as like this gold standard of justice. But at Nuremberg, there were no appeals. Once the sentence was announced, they were, swinging from a rope within a week. In the military commissions, there are 4 layers of appeal: to the convening authority, to the Court of Military Commission Review, to the D.C. Circuit, and to the Supreme Court. So there's an extra layer in there that as a service member I wouldn't get.
And also, just that's a feature of the revised military commission system. In the initial military commission system, there were no appeals to civilian courts or anything but a newly created appellate panel handpicked by the Secretary of Defense. And that was all that was in the first one.
Anthony, can I ask you a practical political question, or maybe impractical political question? This comes along the line of what went wrong, because I'm hoping that next time around this doesn't. So Obama established these task forces, right, that sort of surrounded this issue one way or another. And basically, it was a discussion between extremes, right? And the idea was to take everybody, as I understood it, the president's idea was to take all these different opinions and passions into play. And so people kind of gave on maybe their extreme versions. Is that now a mistake? Because it seems that in the negotiation of what you'd give up and what you'd take, and I don't mean you personally, but each side, somehow the entire project was lost before we knew it. And do I have that wrong? Is that?
I think a couple things. I mean, what went wrong? There were some very good people. This is where I will cede to the chair. There were some very good people who I interacted with who were doing the client review of the files, taking the 200, 300 or so, and then marching through them to see where they had evidence, would it hold up. And from what I hear from people's reputation, from a couple of hours of speaking with them and hearing more about how they interacted with other lawyers, working with NACDL and the ACLU lawyers, I think they had some very competent people doing that part of the review. That task force, I think, was among the best ones. The ones that are looking more at the policy, which was not these group of guys, but another group, which was interdepartmental of DOD, State Department, DOJ. I think you have to go back and look at this is a great idea because you're giving me an idea for what we should do next. You go back to the words of the executive order. It sounded so strident and so bold. And yet when you read the fine print, there were a lot of mays in there. The Department of, the Attorney General was put as the chief to review the Guantanamo policy. And he was to do so in consultation, I'm doing this all in memory, with the Secretary of Defense. Why even you would have included the Secretary of Defense in that kind of leadership role, especially when they enumerate the agencies that were a part of it, they had the Joint Chiefs of Staff, if I remember correctly. So you set up a process that you tried to hedge what was a pretty unconditional promise, but you gave yourself some wiggle room in case you needed to kind of back out of it. And I think that part of what you do in politics is if you keep your own exit door at least marked for you on the way out, your opponents are going to push you out the exit door and not let you walk in the front door the way you want. And I think, frankly, the idea that it was his first promise in office, and yet everything else got behind the healthcare bus, didn't work to his advantage. It's notable that this administration, I think, if they accomplish health care, would be a success for them. But the lack of success everywhere else, this is an administration that couldn't walk and chew gum. I mean, they weren't able to push through a lot of other promises they made, and they keep throwing balls in the air. Don't ask, don't tell in the State of the Union speech. 1 year, another ball in the air. Immigration reform, another ball in the air. And frankly, I would have preferred, I say this in retrospect, and I gave a big party after the executive orders, I would have preferred deferring this rather than just announcing this and then letting it be the stepwife to another agenda that would soil your ability to get this done. You take a bite of the apple, you want to eat the whole thing. Don't put the apple down for a year and come back to it and still think it's going to be healthy.
I think what went wrong in the context of the federal criminal trials, Karen, is that hesitation. If on November 13th, Attorney General Holder made the announcement that these trials would be in New York, and they delivered them to New York on the 14th, which obviously they had to give a 45-day notice, but they could have given that back in July. For these, if they were here on the 14th, this case would be underway, and there wouldn't be any question about it. And all of this politicking and grandstanding and red herrings and fear-mongering would be fall on deaf ears, because the case would be ongoing without the problems that everybody, the Chicken Little atmosphere that's here, because it can be done without that.
The only thing I'll add
and
to
the same
that,
thing with Guantanamo. What Anthony says, you say it in January, you don't do anything about it until November.
look, even the stage crafting of the announcement of the Guantanamo trials coming to New York was fundamentally fumbled. If you play football, if you want to announce that right, you'd have the Attorney General make the announcement. You'd have some of your great U.S. attorneys in the room flanking them. You'd have the mayor speak. You'd have Ray Kelly up there. You'd have Nadler, some silking stock Republicans from the Upper East Side. You put them all up on the dais. You all make them cheer for the announcement. You all give them a little bit of the love and the print and the ink and the Klieg lights. When you go it alone, just by making a phone call the morning of, haven't made the allies you need locally. It's politics. It's anyone who stages an event. We always figure out that you have to balance it out. That's why I think Mo and I and Josh are on this panel. Karen wanted to have some balance. Someone who would say the military commissions can work. And I think, frankly, that's unacceptable from professionals who have to manage politics. In the biggest announcement of the Attorney General thus far, I think it's absolutely inexcusable for them to have handled it this way. And from private conversations of members of Congress, it was their egos more than their concerns about money and security that were most snubbed and then ended up in this context.
I guess I would just say, if they do decide to go the military commissions route, then I think it ought to be turned over to DOD and become a military mission. The current chief prosecutor is John Murphy, who worked for me. He was a DOJ attorney. He's a great guy, but now they put a uniform on him and made him, the chief prosecutor of the military commission. And that was always kind of the game when I was there. DOJ looked at the cases, thought they would not stand up in Article III courts, so we'll put a military uniform on it and call it a military commission, but we'll pull the strings behind the scenes. So I think they ought to make a decision on which route they want to go. If it's going to be in Article III courts, and get DOD out of it and make it a DOJ function. But if you're going to call it a military commission, then give it to the military and get the executive branch, the DOJ part, out of it.
Are you assuming that the military wants it? But there has been a lot of conversation recently that perhaps some of the people in the Pentagon want it, but the military, the legal corps of the military, the JAG Corps, may not want it. Is this what you hear?
Yeah, well, the uniform side, the Judge Advocates General from the start, from back to 9/11 in 2001, have, I think, if anything good has come of this, is the reputation of military attorneys and judge advocates, that they were the ones that were standing up and say, do the right thing, apply the Geneva Conventions, treat these guys as POWs. And it was the political appointees, the big brains that had never worn a uniform a day in their life, that wanted to go a different route. So, the military, we're kind of getting left holding the bag. After 8.5 years, we've created this mess. Now, here, take it and fix it, is a tall order.
Okay, well, our time is out, but I think that I can't sum up everything, but I think that the lack of leadership, a lack of an articulate mission, has really left many in the room feeling a little bit disappointed about the course of events. I think also the fact that I couldn't ask a prosecutor to come up and talk here, or a representative from the Department of Justice, because it's not their job to argue this case, makes it even, harder to educate the American public about what's at stake here. So I hope you've learned something, and I hope we see you next time. Thank you for coming. Thank our panel.